Hello and welcome to our Autumn 2025 Data Protection Update webinar. Okay, so for those of you who don't know me, my name is Martin Sohm. I'm partner in the commercial team at Brody's, one of the data protection specialists here, and I'm joined today by Grant Campbell and Christine O'Neill. And we are going to be following the usual format today of looking at some of the sort of key developments in terms of data protection and related issues over the last 6 months since we did our last update back in May. So if we just jump forward to the agenda today, so what we're going to cover, I'm going to kick off talking about the DUA Act and where we are with implementation of that. I'm then going to hand over to Grant, who's going to talk about some ongoing consultations that the Information Commissioner's Office is running. Some of those are tied to the DUA Act, some of them relate to other matters. Grant's also then going to cover international transfers and the Latum case, which we had in the last couple of months. And then Christine's going to talk about the Court of Appeal's decision in Equinity about group actions for data protection claims, and then the monetary penalty notices that the Information Commissioner has issued to Capita and to Birthlink. And then at the end, I will finish off by talking about the Cybersecurity and Resilience Bill, which was introduced to Parliament last week. We will be sharing the slides after the event, so do sit back and enjoy it, and then we will share that afterwards together with a recording as well. But as ever, we always find with this, we look at the agenda, we try and decide what to cover, we look at the key things, and if we can jump to the next slide, even last night, this morning, we were realizing there are more stories to cover. So some of you may have seen yesterday the announcement from the European Commission with its digital omnibus proposal. So this has been trailed for some time, and the draft proposals were leaked a few weeks ago. We now have that. And within that, this is where the Commission is setting out its proposed amendments to GDPR, but there will also be some proposed what they call innovation-friendly AI rules, simplifying breach notification obligations across cybersecurity laws and GDPR, and also the long-awaited changes to rules around cookies and tracking technologies. So that was published yesterday. We're not going to spend too much time on that today because at this stage, all we have is the Commission's proposals, and it will be some time before they become law. But I think just another reminder, as ever, that this is a very fast-moving space. There's always lots going on, so we do our best to keep you up to date, and hopefully over the next 45 minutes, hour or so, we will bring up to date some of the other key developments over the last 6 months. So moving on to the DUA Act, so we can just jump forward to the next slide. What I want to do today, I'm not going to go through what's in the DUA Act. We covered that back in May, and what we will do in the slides is also include a summary of the key changes, so that if you didn't catch that, you can see the key changes that are coming in. I'm not going to talk to that, but actually what I want to talk about today is just where we are in terms of implementation and the timeline for that, and then what you might want to be doing within your organization in terms of things to look at or to prepare. So the Act received royal assent back in June. And on that date, the enabling provisions came into force. And the other thing that came into force then was the obligations that controllers have in relation to the searches they carry out for doing data subject access requests. So that's the codification of the ICO's guidance around reasonable and proportionate searches, and that came into force on the 19th of June. Interestingly, actually backdated to the 1st of January 2024. So that's in force. We then had a number of provisions come into force in August this year, so they are mainly technical provisions, and we've got the section numbers listed on the slide then. And then over September and this month, we have had a lot of the provisions around the digital verification services and some of the changes being made to the provisions in the 2018 Act around data protection and law enforcement and intelligence services. So they are coming in. They are now in force. And then the bulk of the changes that I guess will be interesting to most people on the call today we're expecting to come into force in January. So we don't yet have the enabling legislation, but that's the timetable that the government has been discussing. And I think the ICO has also mentioned that in its consultation. So most of the areas where there are changes coming in, we expect to come into force in January. And then later next year, changes to the Information Commissioner's Office, so becoming the Information Commission, and some of the provisions around births, deaths, and marriages records, and some other provisions will come in later in 2026. So what should you be doing to prepare? If we can jump to the next slide. Here's a brief checklist, I suppose, of things to look at. So you, I think, will want to look at your legal basis that you rely upon for processing. So that's particularly the case if you are involved in research, or research is an area that you are potentially using personal data for. So looking at what you rely upon there and how you communicate that to people. If you rely upon legitimate interests, then you'll want to look at the new whitelisted legitimate interests, where you no longer need to do a legitimate interest assessment, and whether you want to update your approach on that. There may be areas where you currently don't use legitimate interests, and you might now want to or be able to use them. And if you as an organisation share data with public authorities, then again, you'll want to look at your legal basis for that as well to ensure it aligns with the changes coming in under the Do It Act. Have a look at your DSAR process. So I think most organisations now follow the ICO's guidance around reasonable proportionate searches and follow the guidance around the timelines and when the clock starts and stops. But you want to make sure that you're implementing that within your internal processes. If you use automated decision making, then you will want, I think, to look at the impact of the changes to Article 22, and in particular the narrowing of the application of that article within UK GDPR. Again, that is potentially relevant to research and things like carrying out training of AI models and other such things. So have a look at that if you are doing automated decision making, because it may actually give you a bit more flexibility than you have at the moment. If you transfer data outside the UK, then there are updates to the provisions on international transfers. A lot of that is around terminology, but some of it goes beyond that in terms of the EU data protection test you have to carry out. So you want to ensure that your processes reflect that. If you don't have a complaints procedure, then you'll want to introduce one of those. And Grant will talk a bit about the ICO's guidance on complaints and what it expects. And if you're a charity, then you now have or will have the opportunity to use the soft opt-in for electronic marketing. So again, there's a lot of preparatory work you can do in that in terms of perhaps starting to communicate with people now around how you're going to use that, work out what systems changes you need to make to your CRM systems to manage that so that you are ready to go when those provisions come into force. And then the final area to look at in terms of preparation is around cookies and tracking technologies. So there are new areas where you will no longer need to have consent in order to carry out tracking. But there are, as we discussed back in May, some issues just to work through in terms of how you communicate that, how you give people the ability to opt out of that. So that will require, I think, everyone to look at their cookies policies and the cookie controls, pop-ups, whatever you use on your website, to manage consent and look at how you should be updating that. So that, I suppose, is a quick run through in terms of some of the things that we think you could be doing now to get ready for the new rules coming in next month. And then the other key part of that is new guidance from the Information Commissioner. So I'll hand over to Grant, who will take you through that.
Good morning, everyone. Yeah, as Martin said, there's been a lot going on. The ICO has been busy, a number of consultations on guidance that are being issued in part in implementation of the Do It Act, but also some other significant guidance, which I will take you through. So next slide, please. I'll start with the ICO's consultation on new enforcement procedures. So this is an open consultation. It closes in January 26, which aligns with the dates that Martin was talking about. So this enforcement procedure that the ICO is consulting on will replace the 2018 regulatory action policy that it has and will sit alongside the ICO's finding guidance. It's a very detailed and lengthy document, but it explains the process the ICO will follow when carrying out investigations and deciding what enforcement of action, if any, to take. And in part, this picks up on some new investigatory powers that the ICO now has following the Do It Act. So in relation to things like interview notices, approved person reports, and some expanded powers to request documents and information under information notices. And what the guidance does is it covers all stages from making a decision to investigate through to the process for taking enforcement action. And it covers the factors that the ICO will consider when deciding to open an investigation, the discussion around the alternatives that the ICO will consider. So, for example, just giving advice or making recommendations, issuing warnings, or seeking public assurances, so undertakings, or actually handing off a particular issue to another regulator. So there's a discussion in there about when these things will be considered. But there's the guts of it is around the detailed information on how an investigation is going to be run and the discussion of the various investigative options that the ICO has when it considers them appropriate. So that's looking at these things I just talked about. So when is an information notice appropriate? When is an assessment notice appropriate? When will it look for an approved person report? And also on the interview notices, again, new powers it has under the DUA Act. There's a discussion, a quite significant discussion on the limitations on the ICO's powers, particularly regarding legally privileged communications and confidential information and what the ICO's attitude will be to that. So in relation to some of that information, it may appoint somebody independent to review information if it thinks it is, there's going to be a dispute about whether something is or is not privileged in order to make a determination. And then there's a lot of chat at the end about potential outcomes and when the ICO considers those to be appropriate, and discussion of the various options it has in terms of warnings, reprimands for less serious infringements. The ICO is quite keen on reprimands, enforcement notices, and penalty notices, which leads into the fining guidance, which sits alongside that, and also a discussion about when the ICO will consider a settlement. So actually, it's effectively an admission and a public admission that something has gone wrong, but there are tariffs for discount. So if you were going to be fined, then you may get fined less. And depending on when the settlement is entered into, what the ICO will consider is appropriate in terms of tariff reductions. So it's quite an extensive document. I think it is important for data controllers and processors to understand how the ICO works, and the fining guidance, the new enforcement procedures are an important window into the ICO's mindset when looking at potential action. If we move on to a related topic on the next slide. So this is actually a policy that the ICO has finalized. So there was consultation on this earlier in the year, and this is the ICO's updated approach to public sector organizations. And what this applies to is it applies to bodies that are public authorities under FOI legislation. That could be the UK 2000 Act or the Scottish 2002 Act. Doesn't apply to charities or not-for-profits because it considers those are adequately dealt with under the fining guidance. But the policy that the ICO is promoting is one that's motivated by, I think, three core beliefs. The first one is that encouragement is far more effective than fines to drive up standards. So the ICO has been very evangelical in his mission to try and help public bodies to actually comply with their obligations rather than fining them when they fail. The reason for that being, and this does make a lot of common sense, that fining the public sector actually just reduces the budget for frontline services, and that actually punishes the people who actually need them. And the ICO is also very motivated by early engagement. So they want to be influencing and helping people to get things right rather than intervening only when they get things wrong. So with those three motivations in mind, the ICO's position in relation to fining public sector bodies is that that will only happen in the most egregious cases where it's appropriate and where the infringements are serious. So, and the guidance gives examples of when the ICO considers that fines might be appropriate. So where there is actual or potential harm to people, so the examples given are threats of harm following a data breach, distress or loss of dignity from illegal monitoring, or discrimination or bias in automated decision making. Now, these are just examples, but they give you an idea as to where the ICO thinks the line is to be drawn. The ICO also says that, culpability is relevant. So if there is an intentional conduct or a high degree of negligence, that may move you into a territory where a fine may be appropriate. And similarly, if it's a repeat offender, so actually if a public authority has fallen short before and continues to fall short in the same areas, then a fine may be judged appropriate. But what the ICO also does say is then, even if it considers that a fine is appropriate, then the fining guidance itself, there's a 5-step process in the fining guidance, the analysis of the position of a public sector authority may well determine a lower fine than would otherwise be the case. So ultimately, the ICO, I think, has found that its approach to public sector bodies in terms of not fining them particularly often and trying to rely on other tools, because he genuinely, John Edwards, believes that public bodies are trying to comply, and very much wants to use the carrot rather than the stick. But ultimately, the fine, if there is one coming, must be effective, proportionate, and dissuasive. And that's the general test for all fines under legislation. Next slide, please. Martin mentioned that you need to be thinking about your complaints procedure following the changes in DUA, and this is a consultation that is now closed. So this relates to the new requirements that have been introduced into the 2018 Act by DUA, which requires all organisations to have a process for handling data protection complaints. And the guidance suggests that organisations should look at a number of different channels for, now, not all of them, but think of the most appropriate ones depending on the business, for complaints to be channeled to an organisation. So that may be an online complaint form, a phone line, a portal, live chat even. So you need to think about what is the most appropriate way for complaints to be channeled into your organisation. The ICO also recommends that organisations have a written procedure, which are published on their website as to how complaints will be handled. And the key elements of the ICO's guidance on complaints tend to track the language of the DUA amendments to the 2018 Act. So complaints must be acknowledged within 30 days. There is an obligation which you have under the new legislation to investigate complaints without undue delay. So you need to, not only do you need to be able to recognize the complaints, you need to acknowledge them and handle them without undue delay. You can ask a complainant for more information, and you can ask them about what they're actually looking for by way of outcome, which makes sense given that it is a complaint. So you can have an engagement and a dialogue with the complainant, slightly different from the more restrictive approach on DSARs. You must keep the complainant updated. So you should be setting out a process to regularly advise people about how you are dealing with the complaint and when you expect to be able to respond. There's guidance about keeping records of the action that you actually take, but also, given data minimization, not to keep personal data longer than you actually need it. And then clearly, you need to notify the complainant of the outcome of the complaint, and that they may then go on to complain to the ICO. I think something that isn't often thought about is staff training, a bit like what we've recommended in relation to DSARs is important. You need to make sure that people who receive a complaint know what to do with it, know who to give it to, and that it gets into the system. And there are also some specific comments in terms of complaints by or on behalf of children, but that really just applies the normal rules for data protection in terms of assessing capacity, whether or not a child is sufficiently capable to actually handle their rights themselves. If you are dealing with children, using plain language and dealing with them. And also there's guidance, refers to other guidance in terms of when a parent can make a complaint on a child's behalf, when you have to deal with the child themselves. So next slide, please. Martin also mentioned the new concept of recognised legitimate interest that's been introduced under DUA. So this is kind of pre-approved public interest processes giving lawful basis for personal data processing under Article 6 of the GDPR. Is different from legitimate interest, so the traditional legitimate interest justification that we've had. There is no need for a balancing test against individual privacy rights. So that's the main difference. If you're dealing with recognised legitimate interests, then you don't need to do the balancing test because the pre-approved public interest is there. So there are currently 5 recognised legitimate interests. There may be more and they can be introduced by secondary legislation. But I've set them out on the slide. So sharing personal data with another organisation that's requested it for a public task or official function. Safeguarding national security, public security, or defence interests. I think public security is likely to be the one that will affect or be likely to be used by most organisations when they're looking at that. Responding to emergency situations. There is a recognised legitimate interest for crime, so the prevention, detection, and investigation of crimes and prosecution of offenders, and then safeguarding the physical, mental, or emotional well-being of vulnerable individuals. That's either under 18s, children, or adults at risk. The guidance makes it clear that the requirement for necessity is still there. So the requirement that the processing must be necessary for these purposes, you need to be satisfied about that in the same way really as you need to be with any of the Article 6 conditions. And if you're processing special category data, you still need an Article 9 condition on top. The guidance discusses when the ICO considers that the use of each of these recognised legitimate interests would be appropriate. And it also talks about wider compliance issues. So, for example, aligning your privacy statements to your use of recognised legitimate interests and how you will satisfy those requirements. So this is quite an important piece of guidance if you are thinking that any of those recognised legitimate interests are ones that you may use going forward. So you need to think about that. You need to think about your privacy statement and how you would use those in the context of your organisation. Next slide, please. Martin also mentioned that the DUA Act introduces soft opt-in for charities. Those of you who've been to many of our seminars in the past, you will know that soft opt-in traditionally has been restricted to commercial activities and charities were unable to use soft opt-in. That has now changed or will now change under DUA. We expect from January 2026. So the guidance explains the ICO's approach to this new soft opt-in, and it's structured much in the new soft opt-in is structured in much the same way as the commercial soft opt-in, but clearly there are differences because we are dealing with charities. So the key takeaways from the current guidance, I must stress, this is an open consultation. It closes at the end of the month. But the key takeaways from the ICO's approach as set out in the draft guidance is, firstly, clearly only charities can take advantage of this charitable soft opt-in. As with the commercial soft opt-in, the charity must obtain the contact details directly from the recipient of the data. And it must be in the course of the recipient either expressing interest in the charity's charitable purposes, so that might be sign-ups or requesting information about how what the charity does, or in the context of offering or providing support to further the charity's charitable purposes. So that might be making donations or volunteering for charitable work. But the ICO makes it clear that the activity of just buying something in a charity shop is not sufficient. Now, that might be sufficient for the commercial soft opt-in, and the ICO is very clear in the guidance that the two must be kept separate. So if you're going to rely on the charitable soft opt-in for particular direct marketing, then that communication should be directly within the charitable soft opt-in provisions. You shouldn't be mixing charitable soft opt-in and commercial soft opt-in in the same direct marketing materials. So the sole purpose of the direct marketing for the charitable soft opt-in must be furthering the charity's charitable purposes. As with the other soft opt-in, the recipient must be given the opportunity to opt out when the details are collected, and also in every subsequent communication. ICO is clear again that it's not permissible to use the soft opt-in to market for other organizations. So you can't market for third-party organizations. It can't be used for the charity's commercial activities because the commercial soft opt-in would apply to those. And the ICO also says that it's not appropriate to use it for information that are collected through trading subsidiaries. So a lot of charities do have trading subsidiaries. The charity can't use the charitable soft opt-in for information that comes through that route. And then finally, the ICO's guidance reminds us that the soft opt-in is being used in conjunction with legitimate interest, so legitimate interest assessment should be used as well. Next slide, please. So a lot to unpack in those slides in terms of quite significant guidance coming out from the ICO, predominantly as a result of changes introduced through DUA. Those of you who are regular attendees to these seminars will know that I have talked at length about international transfers, the various sagas that we've had through Safe Harbor, Privacy Shield, and now into the data privacy framework. Well, there has been a decision, so there's been a challenge to the data privacy framework in a case called Latom via the European Commission. If you go to the next slide. So following Schrems 2 and the fall of the Privacy Shield, you will remember that the European Commission and the Biden administration concluded the data privacy framework in 2023 for organizations that are within the data privacy framework. Transfers to them can be treated as if they are within the EU, so there's no additional restrictions on transfers to organizations that have subscribed to the data privacy framework. Well, the challenge hasn't come from Max Schrems, come from someone else, a guy called Philippe Latom, who is a French MP and also a commissioner for CNIL, the French data protection regulator, although he stresses he's doing this in his personal capacity. And he's been arguing that the framework should be struck down because it lacks essential safeguards and does not protect the privacy of individual European citizens with the equivalence required under EU law. And the focus of the attack has been the arrangements within the data privacy framework for the US Data Protection Review Court, which is the kind of judicial remedy, the redress process for the data privacy framework. The court is an essential safeguard under the framework, and his argument is that because it is the members of the court are appointed and can be removed by the US Attorney General, it is not sufficiently independent or impartial to do what it's supposed to do in terms of safeguarding the operation of the framework. He also made a second argument, he made a number of arguments, but these are the two main ones. He's also unhappy that US intelligence services can still do bulk collections of the data of European citizens without prior authorization in the US. And he said that it was a requirement for equivalence that actually there should be prior authorization of those activities by a US judicial or administrative authority. Now, the General Court of the EU has dismissed his case on the basis, firstly, that the court, so the Data Protection Review Court, the members are independent and there are sufficient safeguards in the framework to ensure that they will provide adequate judicial redress. And the court also found that prior authorization was not a requirement of EU law, and that the oversight afterwards by the DPRC was sufficient. So the General Court has dismissed Mr. Latom's case, but the decision is being appealed and it will be appealed to the European Court of Justice. So we don't have a hearing date yet. This has only happened in the last couple of weeks, but the potential for a Schrems 3, even though Max Schrems isn't the litigant here, the potential for a Schrems 3 decision is clear. And if that happens, then again, we will be back into the same place as we were when the Privacy Shield fell prior to 2023. So very much watch this space. And although this is European legislation, clearly there are significant implications for the UK as well. Okay, I think that is all I wanted to say. So I want to hand over to Christine now to talk about the Equiniti decision. Christine.
Thanks, Grant. Good morning, everybody. Yes, this is the particularly depressing part of this webinar where I am going to talk about the Court of Appeal decision in Equiniti and a couple of ICO penalty notices. Depressing, I think, if you are acting for or are indeed a data controller or a data processor. So if we move on to the next slide, I'm sure many of you are following this case. It is a collective action in the English courts brought by members of a pension scheme whose annual benefit statements were mistakenly posted out to wrong addresses because they hadn't been properly updated on the system. And what's interesting about this claim, amongst other things, is that some of the claimants could show that their envelope had been opened by a third party, but not all of them could do that. And those who were not able to show that their envelope had been opened by a third party when it was received at the wrong address had had their claims struck out by the High Court. Those were claims for damages for misuse of personal data and for damages for breach of data protection law. The claims for misuse of personal data were abandoned by the time this got in front of the Court of Appeal, but the data protection breaches remained. Those claims for damages included, for some of the claimants, and I'm going to use this word advisedly, mere injury to feelings. And in some other cases, the case that's pled is that the claimant has suffered psychiatric injury, including exacerbation of other underlying medical conditions. I think what to say at the outset about this case is that it is, in some respects, peculiar because it's very focused on the application for strikeout that was made by the defendant in this case. So much of the Court of Appeal discussion is about the adequacy of the claimant's pleadings, but also about the jurisdiction of the English courts to strike out claims as effectively being an abuse of process. So it is an interesting and important case, and it is one to keep a further eye on because, as I'll come to explain, the decision of the Court of Appeal has been the subject of an application for permission to appeal to the Supreme Court by Equiniti. So things are not entirely settled, but there are some peculiarities about the way this came before the court that I think requires it to be treated with some caution. So the headline is that the Court of Appeal upheld the claimant's appeal in August of this year. And one of the key grounds on which the appeal was upheld was the argument made on behalf of the claimants that actual disclosure to a third party is not an essential ingredient of a viable data protection claim. So it was not necessary for all of the claimants to plead that their envelope had been opened by and their information seen by a third party, it was sufficient at least to get them into court and beyond this application for strikeout for them to refer to other processing on the part of the defendant, inappropriate processing on the part of the defendant, whether or not there was actual disclosure to a third party. So if we move on to the next slide, as I've mentioned, Equinity's position was that the claims should be dismissed as an abuse of process on the grounds of being, in essence, factually incredible or trivial. And the outcome was that the Court of Appeal held that the High Court had been wrong to strike out the claims. Proof that the data were disclosed is not essential to an allegation of processing or infringement of data protection law. Further, an allegation of distress is not an essential ingredient of a tenable claim. And again, this goes back to the point that some of this is quite technical pleading material. Some of the claimants had used language other than distress. They had talked about irritation and frustration, but they'd also talked about anxiety and words other than distress. And the court held that one was not to take an overly formalistic or legalistic approach to that issue, and the word distress or the allegation of distress did not in terms have to be made. Importantly, the court also held that there is no threshold of seriousness in EU or domestic data protection law, which has to be overcome before a claim will be statable, and if it's not overcome, would lead that claim to be the subject of a successful strikeout application. This, I think, is well understood to have been a departure from the previous law in Lloyd against Google. The court took the view it was not bound by that decision because it had been taken under earlier data protection legislation, albeit that earlier data protection legislation was not substantially different in terms from the current Data Protection Act. I think the case is also of interest for those of us with some interest in what the courts are doing post-Brexit with Court of Justice case law. You will see if you have cause to read this judgment that the court relies very heavily on the jurisprudence of the Court of Justice, and also makes the point that data protection law is international in its scope and effect, and seems to use that as a justification for having particular regard to Court of Justice case law. And then what the court says is that the actual harm or damage suffered by a claimant needs to be dealt with on a case-by-case basis. And one of the difficulties that I have not managed to get my head around, and it applies in a number of cases I'm aware of that involve collective proceedings, is just how exactly class actions or collective proceedings will deal with the particularisation of harm or damage at an individual level. It may be that others on this webinar have the answer to that question, but I certainly am finding it difficult to understand how that will be dealt with in the context of collective proceedings. In any event, Equinity has applied to the Supreme Court for permission to appeal, and we will see in due course whether permission is granted, and if so, what the Supreme Court has to say about these various issues. If we move on to the next slide, I mentioned I was going to deal with two monetary penalty notices. The first one relates to Capita. And I think for each of these penalty notices that I'm going to look at, one of the most interesting things about them is the way in which the Information Commissioner sets out his reasoning on the actual figure arrived at for the monetary penalty, and in particular how he gets from what begins at a very high level down to a lower level in terms of the final monetary penalty that's ultimately imposed. So if we move on to the next slide, this monetary penalty notice in relation to Capita, it was issued on the 15th of October this year relating to a cyber breach in March 2023. And that of itself is of some interest. So it's of interest because it demonstrates the very considerable length of time that can pass between a breach and the final outcome, if I can put it like that, with the ICO. And that can be both disadvantageous and advantageous. Clearly, the length of time that an organisation is, if you like, under the pressure of an ongoing ICO process and the length of time that can be taken to get to resolution, that can be a burden on the organisation. Equally, as we will see, the length of time between the breach and the final decision does give an opportunity for a data controller or data processor to take mitigating action, and that can be very helpful in the context of the final monetary penalty notice. So the slide notes that Capita acts as a processor to pension schemes. Those of you who've looked at the monetary penalty notice will know that there were 6 Capita entities involved in this matter. Capita PLC was both a controller and a processor, and there was also a subsidiary pension company that was purely a processor. There were 4 other companies involved in the group, but they were not themselves the subject of the monetary penalty notice. So ultimately, it's Capita PLC and Capita Pension Services Limited who are the entities that are the subject of the monetary penalty notice. And I will come back to that group element when we get to the actual level of the penalty. So it's obviously a very substantial breach in terms of scale. Personal data of 6.6 million people were compromised by a cyber attack. That included pension records, staff records, customer details, and in some cases criminal record information, financial data and special category data. And it arose because of a cyber attack involving a malicious file that was unintentionally downloaded onto an employee device. Action was taken. There was a high priority security alert raised very, very quickly, and some immediate automated action was taken. But notably, from the ICO's perspective, one of the problems was that the device in question wasn't quarantined for 58 hours. So if we move on to the next slide, the breaches are described at length in the monetary penalty notice. They included failure to prevent privilege escalation and unauthorised lateral movement. So essentially ensuring that you have, or failing to ensure that the right and appropriate permissions and security measures were in place to ensure that only those who needed to know were able to access data, a failure to respond appropriately to the security alerts, and inadequate penetration testing and risk assessment. And the ICO goes on to talk about what could have been done in relation to each of those failures. As I mentioned, for me, one of the most interesting aspects of this is the way the monetary penalty was ultimately reached. The ICO had originally proposed a fine of £45 million covering Capita PLC and Capita Pension Solutions Limited, sorry, solutions, not services, as I think I said earlier. Now, in coming to a much reduced fine, the ICO had regard to a number of mitigation measures that had been taken by Capita, including 12-month credit monitoring for affected data subjects, appointing a third party to monitor the dark web. Capita's engagement with a range of regulators counted in its favour, as did its admission of liability. But what's interesting about that is the ICO notes that it would have thought of a more substantial reduction had the admission of liability been made faster. So it counted in Capita's favour, but not quite as much as it might have done if there had been an earlier admission. Having taken account of various mitigating factors, the ICO brings down the proposed level of fine, but not to the final level. What gets to the final level is an assessment of proportionality. So the ICO talks in particular about the fact that while it was dealing with two different entities, they were part of the same group. Essentially, the burden of the fine would be borne by the same group, and he was concerned to ensure that there was not double punishment for the same breaches. He also had regard to Capita's overall global financial position and exercised his discretion to make a further reduction because ultimately Capita um, agreed to a voluntary settlement. So it's actually a very interesting and educational decision on what you can do if you do find yourself in a breach scenario to get to a place where you have good things to say to the ICO about mitigation and good things to say about the proportionality of any proposed penalty. And then finally, a different case, a very kind of sad and unfortunate case, if we move on to the next slide, which is the BirthLink monetary penalty notice. And if we move on again, some of you may be aware of this. This was a monetary penalty notice published on the 24th of June relating to the destruction of records in April 2021. So again, quite a lengthy period between the breach and the final decision. This involved a Scottish charity which is involved in adoption and maintained an adoption contact register that allowed adopted people, birth parents, adoptive relatives, and birth relatives to register details with a view to being linked and reunited. And what happened here is that the charity and it's fairly prosaic. The charity needed more room in its filing cabinets, and it went about creating that room by destroying certain manual records that it held. One of the other interesting things about this case is that issue as a data protection issue came to light not because of a complaint by somebody who was affected, not because of any involvement of the ICO at the outset, but because of a care inspectorate inspection. So a quite different regulator inspecting the service provided by BirthLink, who raised concerns about what had been done, and BirthLink eventually made its own notification to the ICO. I've said in the slide that the impact was on potentially 4,800 individuals. It was acknowledged by the charity and is recorded in the monetary penalty notice that actually the number of individuals affected may be impossible to accurately calculate because of the way in which records were destroyed, and those records included things like letters from birth parents to their children who'd been adopted, photographs of babies, and other personal items. So if we move on to the next slide, the failures you would anticipate, there was a failure to take appropriate organisational measures to ensure the appropriate security of the personal data, failure to comply with the data protection principles, failure to report the breach, and the ICO held that physical, material and non-material damage was likely to result. This charity did not have good data protection policies and processes in place. It had failed to implement appropriate policies and had failed to give proper staff training, didn't have a data retention policy, didn't have a data destruction policy, and didn't have sufficient internal approval processes. The ICO found the breaches to be serious, but and I suppose this is a good point for the charity, those were negligent rather than intentional breaches. However, it also found that there was no evidence of steps having been taken to mitigate the potential impact on individuals affected. The fine started in terms of the calculation at a very substantial number, tens of millions of pounds. It was eventually reduced through a similar process undertaken by the ICO to £18,000. That was really by reference to the charity's turnover and submissions that had been made on financial hardship. But again, a very interesting monetary penalty notice in terms of just setting out what can be done when you have a breach to try to mitigate any ultimate fine. That's all I was going to say, and I think it's back now to Martin to round things off.
Thank you, Christine. Yes, I'm just last section of today's webinar. It's going to be on the Security and Resilience Bill. So this was introduced into Parliament last week. So just a bit of background, if we jump to the next slide, around cybersecurity laws in the UK. So we have the NS regulations 2018, which implemented an EU directive, and they imposed security and resilience obligations and corresponding breach reporting obligations on what were called operators of essential services and digital services. So the focus of the NIS regs was very much on key sectors, so energy, transport, health, water, and then digital infrastructure. And then in terms of digital services, online marketplaces, online search engines, and cloud providers. So quite a targeted set of laws which focused on sectors which were deemed to be of critical national importance. So energy networks, transport, health, water, all very important, and then some digital services as well. And the way that is then regulated is that each of those sectors has a different regulator. So, for example, Ofcom has some powers, Oil and Gas Authority has some powers, the ICO regulates some sectors, the Department for Health and Social Care regulates some sectors as well. So we've had those laws in place for 7 years now. And if we jump to the next slide, um, that I think is the key thing here. These laws are very old in an area that is constantly evolving. Cyber threat is constantly evolving, and there's a recognition that the current laws are outdated and don't really work as they're intended to do, which is fundamentally to protect critical national infrastructure, to protect the economy, to protect organisations within the UK. So we have within the EU the NIS2 directive came into force last year. So that, although it's not been implemented in all member states yet, but that came into force last year and it made a number of updates. I say there's recognition, I think, in terms of the sectors that are covered, that they are quite narrow. And the other big change, I think, is the change in how organisations now rely upon, or at least the recognition of how they rely upon third-party IT providers. So I'm sure pretty much everyone who's on today's webinar within their organisation, there will be a dependence on some third-party IT provider in terms of your IT, and actually you're not necessarily running that yourself. It's outsourced or managed by a third party. And then the final driver is, again, this recognition that this is a fast-moving area. The current laws don't enable the government to act quickly, so the government, again, was keen to actually introduce new powers to be able to react more quickly to new threats. So I say we have the bill. It was introduced last week, and if we jump to the next slide, I will just quickly take you through what it will do. So in terms of sectors and services, data centers will now be in scope, so that will apply to medium and large and enterprise data centers. Managed IT service providers will be in scope, and this I think is, for me, one of the biggest changes, and particularly, for all the organizations out there who rely upon a third-party IT service provider, actually your service provider will likely now come within scope of this, and that I think will make quite a big difference in terms of cyber resilience for many organizations. So that's quite a big change. Also, what are called large load controllers. So they are people who manage the electricity network, for example, for dealing with things like EV charging and balancing. And then there's also the ability for regulators, and interesting is it's regulators, not with the government, to designate particular entities as being critical service providers within their sector. So the example given in the government summary of the bill is a cyber attack that affected pathology services within the NHS where they were outsourced. So that's the sort of thing that the government has in mind here, which is quite interesting because a pathology provider is probably not, it will use IT, but it's not an IT provider, but actually the ability, if that pathology provider's systems go down, that has a big impact on the NHS. And it's back to this point we talked about before around the importance of looking at your supply chain when actually trying to manage your cyber risk. Enough, it's not just about your IT providers. Interestingly, unlike NS2, the government's not proposing to bring manufacturing of food and drink into this. So, we've obviously had high-profile attacks on people like Jaguar Land Rover, Marks and Spencer, and the Co-op. They wouldn't come within the scope of this. And that I think is quite interesting from a macroeconomic perspective, because the last update on inflation actually called out the impact on the Jaguar Land Rover cyber attack on manufacturing in the UK, and then the impact that that had on the wider economy. So interesting that that is not in scope at the moment anyway. In terms of enhanced reporting obligations and regulatory powers, notification is being beefed up, so that you will now need to make an initial notification within 24 hours rather than the previous 72 hours, with a full notification to follow within that 72-hour period. There will also be some customer notification obligations on certain regulated entities, so data centers, managed service providers, digital service providers. They will now have to tell their customers about incidents. There will be data sharing between regulators, and also the ability for regulators to recover some of their costs here. So interesting to see how that is then implemented. And in terms of enforcement powers, the maximum fine will increase to 17 million, or 10% of turnover of that entity. I mentioned in terms of government powers, one of the things that the government was keen to do is to be able to react more quickly. So again, the bill contains the ability for the government to make changes by secondary legislation, so should enable it to act more quickly, but also the ability to direct regulators and regulated entities to respond to imminent threats. So if there's a particular threat that's been identified, then the government will have the power to make certain directions to try and mitigate or the impact of that. On the enforcement as an implementation timetable, some of these powers will come in on day one, but actually quite a lot of this will be done by secondary legislation, and there will be consultation with the new sectors and services that are brought within scope. In terms of how that is done, there's obviously going to be a lot of secondary legislation around this, so there will be a good bit of engagement, which the government anticipates kicking off during the course of 2026, assuming that the bill makes its way through Parliament fairly quickly. So that was all I was going to cover on the bill. In terms of questions, we've had a few questions, and Grant, you seem to be the recipient of many of these questions. What I'm going to do is we've had quite a few in the Latom decision, so I'm going to try and summarize them into a single three-part question for you. So I suppose question number one, do you think it's likely that the data privacy framework will be struck down by the CJU? If so, what would the impact of that be on the UK, and what can UK and EU, or organisations that subject to UK and EU law, do to mitigate its impact? Should they still be relying upon the DPF? Should we go back to standard contractual clauses? What do you think about all that?
Right, I'll tackle these three parts, but not necessarily in the order in which they were given to me. So, firstly, will it be struck down? I think it's hard to call. The CGEU has shown that it is not at all worried about causing chaos by actually making decisions to strike down these things in the past. I think what's actually quite interesting this time is that it's not Max Schrems, it's not a privacy campaigner per se. It's actually someone who's part of the DP establishment in France who's actually unhappy with this. The one thing I would say on the other side of it is that the European Commission have been bitten twice on this, and I think they put a lot of work into the DPF to try and make it bulletproof against attack. So the General Court gave fairly short shrift to the arguments that were being put to it. So I think it is genuinely hard to tell whether or not will happen. Using other approaches, I think a lot of clients and a lot of tech providers, even within the DPF, have used other things, whether that's standard contractual clauses or other methods, as a belt and braces approach to ensure that they're not left high and dry if the DPF fell, because we always knew that it would be challenged. So I think if you don't have other things in place and you are transferring data under the DPF, then I think it is worth considering whether or not there are alternative bases that can be used, because they may take some time to put into place. What's the impact on the UK? Well, the UK is using a bridge mechanism that's piggybacking on the DPF that was concluded by the EU. As a result of Brexit, we do have the ability to do different things. Whether or not we could do different things and maintain the trust of the EU for an adequacy decision, I think would be quite an interesting question. The other thing that I would say that I think is different to 2023 is just the nature of the US administration. If the DPF wasn't successfully attacked, would it be possible to conclude something else, something stronger with the current US administration? I think I have my doubts, although actually I think that would become much more of rather than a data protection discussion, I think that would become much more of a horse trade in terms of things like trading relationships, tariffs, and all that kind of stuff. We're beginning to see data protection, I think, rather than just being a standalone issue, being something that is seen in a much more economic sense as being part of the wider trading relationships that countries have with one another. So that's my views.
Good. Thank you. That's really helpful. I'm conscious that's us at just gone midday, so we've reached the end of our time. Thank you very much for joining us today. A quick plug for our commercial law update webinar, which we do every 6 months. We will be sharing a link for that early in the new year, but do come and join us for that, where we will cover lots of issues relevant to those just dealing with contract commercial matters. So thank you very much for joining us, and we hope to see you soon.
Thank
Thank
you.
you.